Oh, good morning, everybody, both to those here on the committee and to anybody who's watching us out in the community. This is the September 10th meeting of the Policy Review Committee. I want to call the meeting to order and start with the roll call, please.
Chair Brown,
Here.
Mr. Cole, Dr. Pierce, Ms. Beasley,
Here.
Ms. Klein,
Present.
Ms. Ellingson,
Here.
Mr. Holt, Ms. White.
Here.
You have a quorum.
Wonderful. Wonderful. Well, we're going to get back to some matters that have been on our agendas for the last several weeks that we didn't get to. And just before we do, want to mention that policy 5421, which we spent all of our time on last meeting, and then at the end of that, it was tabled. Well, that policy has gone back to the administration and will be reworked, redeveloped. So that's not on our agenda at this point. It is not before the committee. But the administration is going to take a new approach. They will take into account the feedback that that we provided, and we'll likely see something again in the near future. But in the meantime, the schools are able to go ahead with what they wanted to, what they needed to, and even without the change in policy. Does anybody have questions about that?
Yes, Board Member Brown, I do. When you say go ahead with what they wanted to do, could you be a little more specific?
I'm sorry, Phil, I'm not able to hear you.
Can you hear me now?
That's better.
I'm sorry. So if you could explain with what you had to say with they would go ahead with what they wanted to do a little more detail.
Well, I think that it was involving the change to semesters, and that was not something that required change in policy. And anything that would have required a change in policy, they've not done. We did, I did prepare a memo that explained some of those things. Did you not get a copy, Phil?
That would be a yes. We did not receive any copy, nor have we had any conversation or any kind of outreach about this from the administration whatsoever.
Well, I'm not sure that they've picked it up again yet to do anything with, but I'm happy to forward a copy of the memo. I thought you were on the distribution, but
That'd be
happy
great. Thank
to
you so
send that
much.
over. It was just basically my summary of what occurred at our meeting and what did not, so that everybody was clear. There was a mistaken belief at one point that because the recommended changes were tabled, that the underlying policy, which has been on the books for a number of years, was also somehow suspended. And the main point of my memo was to clarify that that was not the case, but that the underlying policy, without any of the changes, was still valid and in effect. So, you know, we'll forward that over, and to my knowledge, you know, it's entirely back with administration, and I'm not sure, you know, when they will pick that up or do something with that.
Thank you.
Chair Brown, do you mind if I just share a point as well?
Go ahead. Sure.
Committee members and specifically to Phil, the administration has committed to having the dialogue with the committee members that we suggested on that subcommittee. So with counselors, teachers, parents, high school math teachers, to look at that entire policy. So while Committee Chair Brown has sent out that memo indicating that due to administrative authority, they are able to move forward with semesters. I do want everyone to be just very aware and clear that we will move forward with that subcommittee. We will have hopefully rich dialogue about the elements that are within that entire policy.
Great. Any other questions on that matter before we get into our agenda? Very good. We first up on the agenda are the minutes of 3 previous meetings. And let's see if I can find them. Yeah, these are from August 13th, July 29, and July 31.
We accept the minute meetings as recorded unless any of my committee members have objections or revisions to make.
We have a second?
Second.
Thank you. Any discussion? Roll call, please.
All right, now I'm unmuted. Sorry about that. Chair Brown,
Yes.
Dr. Pierce,
Yes.
Ms. Beasley,
Yes.
Ms. Klein,
Yes.
Ms. Ellingson,
Yes.
Ms. White.
Yes.
That motion carries.
Thank you. And then we will turn to the policies. And as I mentioned, some of these we've seen before. First up, Dr. Roush would be states of emergency. And
Yes,
this includes the July edits. Go ahead.
Correct. So before you, here are the edits that were made at our last committee meeting. So that we are working from this. I have the original draft as well, so don't worry, since I know no one the committee's not taken action on this yet. Also at that meeting, you'd requested we have a conversation with, there were some concerns regarding collective bargaining language that were raised by our friends of CEA and OPSI. And so we did add a phrase, such action under the suspension of policies, such action shall be in compliance with any collective bargaining agreement, so to make sure that the collective bargaining agreements are in place and we're not doing anything to modify those. So we just wanted to clarify that point. So that when these policies are suspended, any of those suspensions cannot conflict with the provisions of a collective bargaining agreement.
Well, any questions about this?
Not a question so much as actually a question. And while I appreciate the change, ORC 3313.47 speaks to management control of school districts. How does this policy dovetail with our revised code? Because in essence, and I understand the intent of the policy, but in essence, this abdicates the role of the board, who is solely vested in the policy and the management of the district, to the superintendent. And in my area of concern, allows the superintendent to supersede the authority of the board.
I think that this policy really doesn't supersede, superintendent would not be superseding our authority, but it would change the way in which we operate so that the superintendent could do things that were necessary while reporting those to the board, and the board would still have the authority to act or not to act. But I don't think it takes away anything. It simply empowers the superintendent to act more quickly, and on her own, it's still going to be actions that conform to board policy. And in the absence of policy, she has the discretion to use her judgment. So I guess I don't see it that way.
If I could just comment as well, one of the things the subcommittee was concerned about when we were drafting this language was to make sure that the delegation of this authority was very narrow, and that the board would either ratify and agree with the actions taken by the superintendent at the next board meeting and with immediate notification, not only to the board, but to all members of the public, and of course now to in compliance with the collective bargaining agreement. That's an important additional backstop. But of course, a board can delegate specific authority, and they can ratify those decisions after the fact. So our goal here, especially with the procedural protections here and the notice and the expiration of those emergency actions upon the next board meeting, those are in my mind, those are the control that the board is exerting over all of these, any exercise of this particular authority.
So if I can add to, I want to agree with Phil Hayes. Again, I think that we have current policies in place that if emergency action needs to be taken, that a meeting can be called, by a board meeting can be called. We need to have additional guardrails with this policy. Are the actions that the superintendent can take related to a budget? So for example, if we need to get 1,000 Chromebooks out in a quick state of emergency, can you then move your budget dollars around to do that in a very quick manner? This policy as written literally allows the superintendent to take any steps or actions that he or she sees or deems necessary to deal with a particular state of emergency. And there's no guardrails that dictate should those actions be related to a policy, should those actions be related to the moving or restrictions of teachers and staff and students. So I do not see the need for this policy, and disagree respectfully with our committee chair.
If I could just comment on the guardrail piece and the Chromebook example, in subsection A, this policy only applies to an imminent threat to welfare or safety of students or staff. So it's really, we're talking about dangerous situations. I can't see how a Chromebook purchase could possibly be covered by this policy. So we try to limit the circumstances that it would cover. Have a link between the emergency it's responding to and the authority that's delegated, and then procedurally a very close time period where there's notice and opportunity for the board to weigh in and either ratify or change what that action is. So, I mean, it might be the case that we have many other policies that apply to specific imminent welfare and safety threats. Maybe we would want to say, to the extent that another policy already covers one, go with that policy. But this policy, in my mind, was really directed at the unknown unknowns that would affect welfare and safety of students, staff, or other folk.
Which I understand, Committee Member White. So let me provide another example since that one was a little too connected to our state of emergency that we're having right now around COVID-19. So let me give you a different example, pitch it another way. Here's another example. Say there's a state of emergency and the superintendent needs to relocate all of our safety and security officers to a particular region to deal with a particular state of emergency. Again, this doesn't state, are we moving staff members to that particular region to deal with that state of emergency? Can she reallocate the budget to hire more safety and security members to deal with the state of emergency in that region? So again, additional guardrails will be needed and necessary.
Let's see. A couple points and then Lois wanted to speak. This policy, number one, I think it is needed and helpful. And the best example is the start of the emergency that we're now still in the midst of, the pandemic. There were lots of questions and lack of clarity by quite a few people about what could and could not be done and how it could be done. And this helps answer some of those questions for people. It's a place that we'd be able to point to and say, here's how we're operating now because an emergency has been declared. Secondly, the policy starts out the very first sentence. It's in effect only until the board meets, either in person, or online, but during emergency, special, or regular meetings. So the board can call a meeting immediately to address the issue. So I think that's at least as important as any other of the guardrails, that the board always maintains its authority to act or not to act or to limit the superintendent in appropriate ways. Lois?
Good morning.
Good morning.
That's my concern right there, the part that you just mentioned, that the board will act. And I know there's been occasions when the board has not been able to get together to act rapidly due to conflict of everyone's schedule. When reading this, I got a flashback of when a previous mayor was trying to take over the school district by using similar and somewhat tactic. So my concern is we vote for the board. We don't select the superintendent. The board selects the superintendent. So I just want to make sure that the board will be the final vote in case of emergency or making major decisions that will impact the district, not leaving that up to the superintendent because she's not the voice of the community. The board is the voice of the community. The board is who we elect, and you come behind us and choose a superintendent. So having this language, I think there needs to be something saying that the board would meet within 24 hours of the impacted emergency or something of that nature to put an extra guard around it so that the community knows that the members they voted for are acting rapidly on an emergency decision and not leaving it in the hands of a superintendent. Thank you.
Thank you, Lois. Other thoughts, suggestions, questions? All right. Do we have a motion to recommend this policy to the board? And the board obviously will have further discussion about this. Anybody want to move this one?
I will move for this one.
Thank you, Emily. Do we have a second?
A second.
Thank you. Roll call, please.
Chair Brown,
Yes.
Dr. Pierce,
No.
Ms. Beasley,
Yes.
Ms. Klein,
Yes.
Ms. Ellingson,
Yes.
Ms. White.
Yes.
That motion carries.
Thank you. Let's move on then to policy 5230. Late arrival, early dismissal.
So this was another policy that went through the subcommittee process pre-COVID. If the committee will recall, there was some concern over the simply we were going to the recommendation was to require photo identification. The subcommittee met, went ahead and wanted to first of all clarify that for purposes of this policy, what the term parent meant. So you can see that definition here for this policy. And then also what was added was that the presentation of a photo or other identification may be required. So it is not a shall, it is a may. Other identification may be used, so that when somebody comes to pick up a student, we can identify and assure who those individuals are. So if a principal knows, they know that, I'm Eva's dad, they see me regularly, they know who I am, they may not require that identification. They may not know who Eva's grandfather is or Eva's aunt, they may request that information. So just kind of using a personal example there. I think I summarized that. Any of the other subcommittee members have anything else to add on that? I think Ms. White and Ms. Ellingson, you were both part of this subcommittee. I know Ms. Ellingson was.
I think that this appropriately strikes the right balance of protecting our students, while also, leaving this matter to the good judgment and discretion of the folks on the ground who know our families and our kids best. I like that it empowers them to be able to require ID, but it also gives them good judgment on, whether or not that is acceptable. And I think it's also appropriately sensitive to many of our groups, many of our community members who may have difficulty having more formal forms of ID.
Very good. Any other comments, suggestions, or questions?
Eric, this is Lois, and the secretaries normally screen ID
Mm-hmm.
for releasing students. And I know we have that electronic system where the parents can swipe their driver's license.
Correct.
So have we vetted this through safety and security? Because safety and security emphasizes a lot about running the ID through the security system. And I just have a concern that we may be going against what they're doing. So I just hope that we're all on the same page. Because they're training the secretaries, you must have ID, you must scan it, you must do this, you must do that. So if we're contradicting the training that they're providing, we need to make sure safety and security is up with this information and now providing the adequate training that the support staff will need when releasing students.
Yeah, that's an excellent point, and I will admit I did not have a conversation with safety and security about this particular language. So I don't know if the committee wants to hold on this one more month or if they want to tentatively approve it with pending safety and security's okay. We have done that in the past. I'm open to either's fine with me. But she raises a good point. I did not think to take this to Chris Ward and his team. So.
I agree that, we do want their thoughts on this. And I'm okay either way. I think that, if there's agreement on this, on this policy change, subject to an okay by safety and security, I think we can go forward. What's the pleasure of the committee?
I worry that what you might get from safety and security is what is rather than what ought to be, what they're training folks on rather than what the policy should be. And I'll just say again, as a parent, I find the presentation of ID, simply to go to and from school, the scanning, the printing out of the badge and all of that, it's a really intrusive process. It just is. And I can absolutely see how that would deter participation from members of our community to go through. I mean, it's almost the level of airport security to visit a school. But I would point out that this particular policy deals with late arrival and early dismissal. So it could include somebody dropping off a child late, or it could include picking up a child who's sick. And so I think that we want to think really carefully about whether, how firm and rigid do we want to be on requiring ID in those particular situations. And personally, I think that this policy strikes the right balance. And perhaps if a discussion is had with safety and security, it might be to build in a layer of discretion for how those documents are demanded or required.
I would just like to point Dr. Roush to our chat box. I think we have an administrator that has shared.
Yeah, and that's from Kevin, who suggests some language for us to consider.
I worry that having different policies in different buildings would really implicate equity across the district. Do we really want to have some buildings that have a more intensive or more intrusive security and ID demands of our families than others? I personally, I think this should be a policy that's flexible enough that goes across the board and is equal in all of our buildings.
That's how I took his comment, that it was providing that flexibility and safety. And so just for the general public to understand what we're dialoguing and discussing right now, the comment that has been put in the chat box by Kevin is that we consider language which directs building administrators to develop and implement building specific procedures to sufficiently document the arrival and departure and to whom students are released if not covered by another policy.
If I may, I know that in the Attendance and Accountability Committee, I believe that there are administrative guidelines that provide for like a standardized sign-in, sign-out sheet, as well as those kind of procedures to document who comes in and out of the building. I don't know if when you were looking at, or as we're talking about this, I don't know if you were looking at any of that documentation and taking that into account. I know with the concern that's been raised.
Phil beat me to it. Yes, there's already some standardization that goes there. With the policy change, this would be something for Attendance and Accountability to take another look at to see if any further modifications need to be made to those administrative guidelines.
Yeah, and I would think that that those items should remain in the administrative guidelines and don't need to be worked into the policy itself. I don't think we need to operate at that level of specifically how it would be implemented. There will be some variation throughout the district, and I think we'd rather minimize that rather than encourage that. But different buildings are set up in different ways and have different people who are actually administering it. I think that, those variations are going to occur no matter what. But the administrative guidelines is really, I think, a better place for anything this specific to be addressed.
Chair Brown, if I may.
Yeah,
And I 100% concur. If it is already covered by an administrative guideline, no need to put it in policy. I was simply thinking of, I think that's fabulous. And I would have expected some consistent or some already direction on the arrival and departure and documenting those. So if that's already covered, then please, yes, absolutely disregard this comment. It's already done.
I appreciate your raising the issue, Kevin. Thank you.
But you raise another good point, which is if we amend the policy, it probably should be something that attendance and accountability takes another look at to say, do we need to now modify our administrative guideline in lieu of the amendments to the policy? So thank you for raising that. We can certainly put that on Dr. Klein's radar since she chairs that committee.
I just want to make sure we're understanding ID or no ID from safety and security. Because I literally have attended at conferences where secretaries have been disciplined for not checking ID and releasing students without checking the ID. So I again will stress that, can we vet this back to safety and security for their input, and then whatever you vote on moving forward, there's proper training given to the staff who must initiate whatever the policy is.
Good points, Lois. Thank you.
Thank you. That is exactly the kind of situation that I think we really wanted to avoid here, which is why we wanted to specifically empower, to authorize that where the front level staff know who the person is.
Mm-hmm. Any other thoughts? I guess.
I just want to add at this point that one of the things that we've heard with this policy and the one that we discussed prior to is we're really missing the feedback loop here. And I want us to be mindful of that. We've discussed 2 policies in which we've noted that we haven't reached out to whether it's frontline staff or whether it's another administrative component within our community, our team. So while PRC, our directive is to review and to implement policy, we can't do that in a siloed nature. It takes everybody in our CCS family at the table giving their input so we come out with effective policies that push and promote student outcomes. We can't do this work in a silo. And so I just want to really bring it to the attention that this is the second time we're indicating we haven't done our due diligence to get the input of, again, front level staff, other administrative arms for policies that we're then sending to the board to yay or nay.
I think that's a good point. And I think that I'm not sure that it's the role of this committee necessarily to do that, but it would be our role to ask and be sure that that's been done. This policy, for example, is not coming from Neola, but these are changes that are recommended to us by staff. And I think that it does make sense for us to make sure that staff have vetted it with all of the appropriate people. And I'm not sure if that's something that we need to do in terms of a change somewhere in policy, or if that's something that is kind of procedural related to how this committee operates. But I agree. I would hope that the staff who recommends the policy changes to us has already done those pieces, and I think that is appropriate.
D-
Why don't we, Eric, do you have some thoughts? And
So-
I'd be happy to discuss it with the superintendent.
Sure. I mean, this is an example where we had brought a policy with the Neola changes, and then the committee didn't like those changes and wanted to go forward. And so we met and revised these. And so I did not close the feedback loop on the back end of that, and I will own that. I have no problem owning when I don't get something done. I will own that piece. When Neola sends their policy recommendations in, we run those through the appropriate area. And, we talk to those administrators and those areas that are in charge of those particular policies. So for instance, if we've got a policy that has to do with HR, that runs through HR, runs through employee relations, they take a look at those things. Remember, a lot of Neola changes are statutory changes anyway. This is something that kind of deviates from this isn't a statutory issue. It was a Neola best practice that they felt, which is why they said they wanted to require ID for everybody. It was a suggestion, and then the committee opted not to take that language and went another route. So in this instance, I would agree this was something where I did not get that back to our safety and security team to take a look at, because on the front end they were fine with the language that was there before, which was the requirement that there certainly be that language. And so I will get that to safety and security. Again, I'm fine if we want to hold off one more month in putting this forward. That's okay. If the committee wants to give its tentative approval pending safety and security review, I'm happy to have Chris Ward come and speak to the committee if he feels that's necessary. If he's okay with the changes and they'll adapt accordingly, then I can bring that back to the committee as well. So I just want to make sure the committee knows that in those areas, especially when Neola sends us those policy updates, we have those conversations. The policy 8000 was a committee driven policy. So
Dr. Roush, I thank you for taking responsibility for this particular policy and not closing the feedback loop. But again, with policy 8000, when we talk about the grade change policy, we are not, as a PRC committee, as our public review committee, doing a good job of ensuring that policies in general have been vetted through our peers, our colleagues, and that we are not doing this work in silos. So please ensure that the record reflect that I, as a board member, am calling to ensure that we do a better job of ensuring that the feedback loop is followed through, that all interested parties are brought to the table before policies are brought to PRC for recommendation.
Dr. Pierce, I completely share your concerns, and I think that that's a great insight that you bring. I've got a suggestion for maybe like a procedural way that we could reach that goal. I like everyone, one of the most important and valuable things, I think, every time I look at a new policy is sort of hearing that background of how did this come to be? What is the problem this was meant to solve? Who are the potential stakeholders? And then, of course, what is the process that has led to this? I wonder if there's some way that we could have like almost like a cover letter or a form that says, this is where, who was involved in proposing this policy. This was the problem it was intended to solve. And then formally go through that process of identifying, here are the potential stakeholders, and then, so that we can know, have they been consulted? Because so many of these, when we're seeing them the first time, knowing it's Neola, or knowing that this is a longstanding policy and we've got a statutory change, like those are no-brainers. But the ones that are internal policies, I share your concerns where we don't, are we getting complete feedback from everybody? And if we don't take the time to think who is affected by this, we will never get that feedback.
I appreciate that, Committee Member White, and I think that will contribute to a richer dialogue as we discuss the policies that are brought forward. So I love the fact that our committee has responded with a suggestion on how we can get that done. So thanks so much, Committee Member White. I appreciate that.
Eric, what are your thoughts about the feasibility of?
In terms of this particular policy, I'm fine with the approval, given that safety and security don't have any changes, or the tentative approval.
Is that a motion, Dr. Pierce?
If you would like me to make that motion. I
Sure.
think you have more to say. Okay, so I motion for the tentative approval of policy 5230 pending feedback and approval from our safety and security.
Do we have a second on the policy?
I'll second.
Anything additional? And I still want to get back after we vote on this to the other question of procedure. Roll call, please.
Chair Brown,
Yes.
Dr. Pierce,
Yes.
Ms. Beasley,
Yes.
Ms. Klein,
Yes.
Ms. Ellingson,
Yes.
Ms. White.
Yes.
That motion carries.
Thank you. Appreciate that. And with respect to the procedure, I think, it's a good idea. And I think, we may need to figure out exactly how that can work. Dr. Roush, do you have any thoughts on the feasibility of having a process like that?
I think putting together a memo is not, whether it's a full memo, or whether it's kind of the cheat sheet that I often will prepare for the board that kind of gives kind of the quick synopsis that's there. It's a tweak to that. I think that I can certainly note which are the Neola recommendations so that we have that very clear, that oftentimes these are statutory changes and that's why the changes are being brought before. But I think is certainly as the committee weighs in on other topics, other issues, we would certainly have to we'll have to add some additional components to that. It's not undoable. It just may take a little more time. And if that's, I'm a firm believer in a good deliberative process. And if it takes a little bit more time, so be it. And sometimes perhaps if it's something pressing from the statutory, because remember the statute takes precedence no matter whether the policy is updated or not, statute supersedes. So we can either take our time with the policy, or if the committee, there are other issues they want to address, they could address with the statutory changes and then come back to deal with those non-statutory or non-conforming changes at another time and work on those policies. So.
If I could offer just one more suggestion too, just thinking about like what information would be helpful in assessing these policies. I wonder if there could almost be like a proponent of the policy, somebody from the administration who could speak to why it's proposed and what the benefits or the drawbacks on, especially on the non-Neola, non-statutory changes, almost like in the legislature where you have the proponent of a bill has to come up and tell the committee members why they're proposing this. And that can be also an opportunity to get into the procedural issues of who all has been consulted, what's the problem that this is solving here. But I also like the idea though of it being accompanied by memo, just so that the public record is a little bit more clear and the community understands what is the problem this was meant to solve in the first place. Before we get into it, and what are the potential, complications that could occur if we made this change.
Some other thoughts? Otherwise, I think that the committee's fairly clear on what we'd like to see, and let's go ahead. And I think we can start doing that, and especially with those policies that are not statutory, not simply Neola changes, that we do create a memo and have a bit more process to them, so that we can demonstrate that that everybody has been included and had an opportunity to provide some input, who needs to be, so that we can see who those folks are. And I guess I'm hesitant to simply insist that an administrator come to us every time that there's a policy recommendation to explain it. I guess I want to be careful about imposing more work on our administrators. But I think that there certainly are times where we should have that. And some of that I think we can recognize in advance and arrange for. And some of that may be a matter of when the committee sees it and begins discussion. If we find that's desirable, we can ask for that at that time. I just hate to make it a blanket rule because that would necessarily involve administrator time more than I think we'd like.
That's kind of what I was feeling. I do, Emily, I appreciate your point about having a concise explanation for members of the public. But just the idea of like producing a memo every time, or like, you didn't say this, but requiring an administrator to be here. I think there might be a more efficient way to achieve the goal, which is just to revise the norms of how we operate here and ensure that we're always asking ourselves, whose lane are we in right now? Who actually has to carry out this policy? And somewhere within, before, someone should be prepared to tell us when we inevitably ask in this meeting, do the practitioners understand and accept this? That's easy. So I don't know that has to be another memo for every policy.
Mhm. Any other discussion on this point? All right, I think let's move forward and we'll try to develop this on a going forward basis and try to make a few changes to the procedure so we can have that. Next policy up. Use of tobacco by administrators. This is a new policy recommended for our approval.
So in short, this is the exact same policy. This is, I think, now the fifth place you'll find this policy, and actually, just I think only the fourth place. I apologize. This is the same policy you'll find under the 3,000 section for professional staff, the 4,000 section for classified staff, under the I believe it's the 8,000 section for operations. Neola has noticed that they did not have a similar policy under the administrator section. And so this is our existing policy just for that other classification of employees. That's it in summation.
Dr. Roush, will we have to change the date on this to Neola 2020, or does it remain 2019?
It's 2019 because that's their copyright date from when they created that policy.
Okay.
That's their copyright date, so.
I motion that we accept policy 1615.
Second.
Thank you. There's a comment from Kevin Sankowski in the chat box. Policy applicable to students refers to discipline for noncompliance. And
there's a difference between a student who's under the age of 18 and an adult who's an administrator choosing to smoke and or use tobacco. And that may be why there's a difference regarding discipline.
I think that's fair. Kevin, did you have additional thoughts?
I don't disagree, other than that these are specific to, on district policy. It's not, or on district grounds and the use on district grounds, and trying to just set that example and being consistent with how we're going to treat students is making sure as the adults, we also set that excuse me, set that example again, just on grounds, not dictating in any other capacity or any other context.
Is your suggestion, Kevin, that there be a phrase added here that would state, you know, if the committee wants to go this route on this one, I'd want to go and do it for the other sections that we have, or at least the others
Certainly.
that apply to employees, perhaps not to the general public. But are you suggesting there be a phrase that's saying that you know, that violation of this policy could put someone subject to discipline or something to that effect?
Yeah, just a very general statement that that's a possibility, and brings that to the attention of the adults that are governed by the policy. Thank you.
There's some further thoughts about Kevin's point. Do we want to add?
Chair, I'm open to adding the same language from the student policy as far as potential discipline to all of the use of tobacco policies.
And that would be a motion to amend what we're looking at to add that statement both here and in the other versions of the policy.
Could Dr. Roush pull up the student policy so we can see that language?
I can. Give me 1 second.
Do we have a separate like discipline policy for administrators? Does it, and if so, does it include language saying, you know, violation of any policy could be subject to discipline? I wonder if we might get there in the other direction.
I'm sorry. Let me bring up that policy, and then I'll answer that. Share screen. There we go. Can everybody see that? So this is the policy that applies to students. And again, there is another policy that then pertains to the general public as well. Although I think there'll probably be less ability to do anything for those individuals. Excuse me. In short, you know, every year employees essentially indicate that they've read the policies, they've read our employee handbooks. You know, I believe, and Phil can correct me if I'm wrong, I think that part of the you know, following board policy, following state law, because you know, state law kind of says that we can't smoke in buildings, certainly. Part of the professional, the code of conduct for professional educators states you'll comply with those laws and regulations. Am I correct with that, Phil? Tell me if I'm wrong.
Yes, you are correct.
So there are other areas where violating, you know, especially willful violation of board policy could result in that, whether we add it into this section or don't add it into that section. Part of it is do you want to call it out to make it very clear to those folks who may just be glancing over the tobacco policy section saying, okay, do you want to really call it out and grab their attention, or because it's part of the overall arching policies, if you violate a policy of the board, you know, that's certainly subject to some form of discipline. So I think it's part of it is how much do you want to do a direct call out in that area. Some policies, I think we've done that. We've done a direct call out. In others, we've not.
My own thought is that the language here in the student policy really doesn't work for the others, and that I don't know that there's any need to specifically call it out. I think that you know, the policy speaks for itself, and somebody who chooses not to comply also understands that there may be a consequence related to that. I think, Emily's thought, and we may have policy somewhere that says that, but as you described, Eric, I think that is the way this works. I guess my thought is that we really don't need to make any other revision to this policy that's in front of us.
So, Ms. Klein, was that an amendment, a motion for an amendment you had made, or was it we still just kind of having conversation in that regard?
I made no motion.
Okay, I just wanted to clarify.
And Lois, did you have something?
No, is my hand raised? I'm sorry, my computer went crazy over here. No, I'm good. Thank you.
Okay. Very good. We have a motion and a second. Any further discussion? Roll call, please.
Chair Brown,
Yes.
Dr. Pierce,
Yes.
Ms. Beasley,
Yes.
Ms. Klein,
Yes.
Ms. Ellingson,
Yes.
Ms. White.
Yes.
That motion carries.
Wonderful. Next up is a policy or recommended changes to policy on gifted education and identification.
So again, this is an update through Neola. Provisions for students withdraw from gifted programs and services, something that that the state wants to make sure we have. We do have an AG on withdrawal from gifted programs and services, so we're already covered in this. And then they modified this section to include amongst laws, rules, and regulations. They wanted to add timelines as well. So Neola clarified that that will implement all policies and procedures in accordance with the timelines and other requirements. I would think that the timeline would be a part of the requirements of their rules, but I think Neola recommended that we do a specific call out to the timelines, and so here it is before you. I think it's just a belt and suspenders.
Any thoughts? Do
I
we
motion
have
that we approve policy 2464.
I'll second.
All right. Anything further? Roll call, please.
Chair Brown,
Yes.
Dr. Pierce. Dr. Pierce, I think you're on
Yes.
mute.
I'm
Okay,
sorry.
thank you. That's okay. Ms. Beasley,
Yes.
Ms. Klein,
Yes.
Ms. Ellingson,
Yes.
Ms. White.
Yes.
That motion carries.
Wonderful, thank you. And we have 3 more before us. And it looks as though these may be similar. Dr.
These,
Ross?
yeah, these again are changes. They're from Neola. They reflect. It's actually kind of interesting. The highly qualified teachers went away several years ago in federal law. So it does strike that highly qualified definition that's there. Adds under that section. Essentially, teachers have to hold a valid license to teach their areas of assignment. Here are the various license types that exist for those areas. And the superintendent has to report state certification of licensure status annually in accordance with state and federal law.
And it
Ross,
sounds
I
as
have
though
a quick
we should
question.
take these one at a time.
Yeah. This is 3120. Yes.
Okay.
Dr. Pierce.
So with 3120, what really concerns me is that as our district is moving to think about equity and how we need to move our highly qualified teachers to our buildings with the highest need, with students that need innovative teachers that are passionate about what they're doing. We're taking kind of the definition away at a time where we need to keep that definition. Legally, are we bound to remove the highly qualified from our policy?
It's a federal definition for what a highly qualified is. If we wanted to keep a definition of highly qualified teacher, we could. There were, under the federal law, we had to report how many teachers were highly qualified. If a teacher was not determined highly qualified, we had to alert parents to that effect. All of those went away with ESSA back almost 5 years ago now. So you can see that it's taken Neola a little while to get to this particular policy to change. If the district wanted to keep the definition, they certainly could do so. I guess the question I would have would be, what would we do with that definition, or what would the purpose of that definition be? It had certain connotations and certain requirements in federal law. Those requirements are gone now. So I guess that'd be my only question. If we keep the definition, what do we do with it? What's our intent? What is our goal? If we maintain
So
it?
our intent, and committee members, please indulge me for just a moment. Our intent is to ensure that we have a solid definition of what our highly qualified teachers are in our district, that it gives our new Chief of Diversity, Equity, Inclusion, Dr. Blue, a standard by which to determine who highly qualified teachers are within our district, to be able to allocate, welcome, encourage those teachers to go to our schools with the most need. I feel that us simply making this change or correction for Neola purposes, while it does align with their purposes to indicate if they have a licensure, we need something more rigorous within our district as we move to really tackle equity.
Dr. Pierce, I fully agree with you, although I'm a little reluctant to try to sort our teachers further into, highly qualified versus not. But the first line of the existing policy, and it would remain even with this edit, is the Board of Education recognizes it's vital to the successful operation of the district that positions created by the board be filled with highly qualified and competent personnel. So maybe if we wanted to make a statement about highly qualified, or even link it up with equity, we could modify that sentence while also making sure that we have the statutory changes that align our like baseline requirements for hiring with the Neola and the federal law.
So I love that point, Committee Member White. I think in this particular instance, though, we're not putting more of a standard on our teachers, because our teachers are used to this definition. They worked under it. Well, our more seasoned teachers, right, have worked under this definition, so they're very familiar with it. And I'm happy that you pointed out that it is in that first sentence. So could we, because highly qualified is in that first sentence, put the actual language from the policy that's been striked from the policy as the definition for what highly qualified is? So refer to this language as a definition.
We could do that. I guess the other question I have is that the right definition? That was the old No Child Left Behind federal definition. Is that the appropriate definition for what constitutes a highly qualified teacher? I'm not saying, I just want to make sure that if we put that in here, we like the definition, or is the desire to have our Chief of Equity kind of help work with our partners in education and determine what is that definition for a highly qualified teacher?
We are rocking this morning, people. Can you feel it? So that's where I think that feedback loop comes in, that we say, this policy came before C this morning. For example, it moved forward. While we did strike out highly qualified from the actual policy, we retained it as a definition, and we give this policy then to Dr. Blue and get her insights on how does the definition need to be reworded, revised, recrafted, as she thinks about how we move forward with our equity.
So would you want to keep the definition in the policy, or leave it to Dr. Blue to work with others to create that definition?
So I would want to keep the definition in the policy, as a definition and give her the flexibility, the invitation to revise the policy definition as she sees fit. And then that definition can come back to us for approval.
I'm fine with sending this to Dr. Blue to look at the highly qualified definition. I mean, according to and I don't know who is commenting on Facebook, but according to the Facebook comments on our Facebook live feed, this definition is not relevant anymore. So I mean, I would suggest that we not approve this particular policy at this time, but send this to Dr. Blue and let her take a look at that before we even take it up.
Did we lose Chair Brown?
We did indeed.
I'm afraid I have to leave the meeting at this time as well.
We did lose Chair Brown.
Thank you,
So
Ms.
right
White.
now, if Ms. White leaves, do we still have can we still take action on this policy, Dr. Rose?
You would no longer have a quorum.
I can,
No, well, you won't have a quorum right now because we don't have Judge Brown. So,
Okay.
so
I
once,
think, Dr. Rose, the recommendation is that we send this policy specifically to Dr. Blue to define what highly qualified teacher is.
and maybe we want to even, you know, since this term had it was a specific term of art that's no longer in use, maybe we want to own our own term.
Mhm.
Maybe this is something, this is, you know, maybe not highly qualified, but super effective, or, you know, great. I don't know, but maybe we should own our own term just to not confuse it with what was essentially a highly technical and credential based definition, which it sounds like might not even be what we mean by highly qualified.
Well, what I can say, what I like about the highly qualified is it does get into the certifications. It does get into having, you know, degrees and expertise in a particular area. And I definitely think there's value to that. And so I'm sure Dr. Blue and our administrators will be able to come up with a good definition. And Committee Member White, I love that idea of changing the title of it. You know, it doesn't necessarily have to be highly qualified. It could just be, you know, as you said, innovative, super. We can think of another title for it.
Just one other thought too, though, is I like where you're going with this, Dr. Pierce, with you know, the equity piece and thinking about where our resources are allocated. But I wonder if that might be better in a separate policy than our baseline. Here are the minimum criteria that one must meet to even be hired in the district. Because I think that's what this specific policy is doing. So just another thought.
No, thank you for. I think there's definite value in separating and making the distinction. With this policy, again, having highly qualified linked in that very first sentence and having that kind of laid out later on, I think it's important that if we are going to have that as the intro into this policy, that we're intentional about how we're defining those highly qualified teachers. Great point.
All right, thank you. Well, I will have to join you at the next meeting. Good luck. Bye.
All right.
so if the committee
So-
can stand at ease for a minute, I'm going to try to help Chair Brown get back into the Zoom.
Okay.
I've texted him some additional information, so hopefully he can log back in. Otherwise, we do not have quorum at the moment. But we can certainly take the policy to Dr. Blue in the interim. If there is no quorum and can't take any further action, then we can go ahead and start working on that definition for next time. Is that good with the acting chair, Dr. Pierce?
That is good with me, Dr. Roush.
Do you want to hold tight and see if the chair can rejoin here for a moment?
Definitely. Let's give him some more time.
So, Dr. Roush, while we're waiting, I do have a question. Does anybody follow up on the comments that are left on the Facebook Live?
For the committee meetings, I have not done so. Ms. Nichols, I know that you do so for the board meetings. Do you grab those from the committee meetings as well? She does not. So we can certainly go and get the comments from the we can go ahead and get the comments from the Facebook Live feed and follow up on those.
You really cannot teach a county auditor about Zoom. Yeah, I mean, I think that there are several comments on here that aren't necessarily related to the policy review committee. Some concerns about the attendance system, and then also a couple of comments about not getting refunds from last year's senior dues that haven't come through. So, I mean, I just think it's important that the district, whether it's a committee or any committee, quite frankly, at least, try to engage and answer some of the questions or concerns that are expressed in the Facebook Live, post meeting time.
No, I'll work with Ms. Nichols, and we'll pull that information and get that to the appropriate places.
I agree 100%.
This is Eric. I'm back in now,
All right.
or at least on the phone.
Welcome, Chair Brown. We missed you.
Thank you. And go ahead, just proceed. I'll listen for the moment.
Dr. Pierce, how would you like to proceed then, now that we have a quorum again? You have 5 members.
So I guess we have the recommendation on the floor to send policy. The recommendation on the floor to send policy 3120 to Dr. Blue, specifically to define qualified teacher, understanding that we may even change that title from highly qualified to something else.
If that's a motion that requires a second, I would second that.
So I put it out there as a recommendation, but I'll put it out there as an motion. So the motion. Any further discussion? Seeing none, Dr. Roush, please call roll call.
Chair Brown,
Yes.
Dr. Pierce,
Yes.
Ms. Beasley,
Yes.
Ms. Klein,
Yes.
Ms. Ellingson.
Yes.
That motion carries. The
All right.
policy will be forwarded to Dr. Blue.
Great. And that's 3120, correct?
That is 3120. That is correct.
All right. Fine. Let's move on then to 3120.04, substitutes.
So the changes to 3120.04 here, again, essentially is another Neola change. This is already what our policy is. Superintendent recommends the board will approve substitutes. You'll see that on your board agenda under the HR section on a regular basis. Employment may be terminated when their services are no longer required. They must have a teaching license to serve as a substitute. That's a requirement under ODE. I think that already in the collective bargaining agreement, that if they hit the 60 days in a specific position, they get placed on the minimum salary on the teacher schedule and are eligible for fringe benefits provided to regular teachers, including sick leave, and then casual or daily substitutes, i.e. I sub today and then I don't sub again for a few days. They don't accrue leave. I think that's all pretty standard language there.
Hey, Eric, this is Phil.
Yeah.
I do know that my understanding is when a substitute goes full-time, as it's mentioned towards the end of the policy, the only fringe benefit they get is the health insurance. I don't believe they get vision or dental.
Okay.
You might want to check with the HR team on that, but it is, I believe it is limited to just health insurance.
I will, I ran this by HR and they were okay with the language that was there, but I will go ahead and see if they feel that we need greater clarification on that point. But thank you.
Dr. Ross, could we put specified fringe benefits there? If they needed additional clarity. So specified, and then that would give them the opportunity to say what those specified fringe benefits are.
That is an excellent edit. Does anybody object to that amendment made by the acting chair?
You got a thumbs up, all right. Is there any further discussion? Seeing none, do we have a motion to approve 3120.04?
Move that we approve 3124.
Thank you so much, Ms. Beasley. Do we have a second?
Second.
Excellent. Do we have any further discussion? Hearing none, Dr. Roush, please take the vote.
Chair Brown,
Yes.
acting chair Pierce,
Yes.
Ms. Beasley,
Yes.
Ms. Klein,
Yes.
Ms. Ellingson.
Yes.
That motion carried.
Excellent. That brings us in good timing to policy 4120.
So again, policy 4120, this has to do with the requirements for the Title I paraprofessionals. So these are requirements under federal law that these that those supported by Title I funds have to meet certain qualifications. So that is there. Some of it's a renumbering and a redesignation. This is another Neola change. And again, just clarification, the superintendent has to report state certification of licensure status for paraprofessionals in accordance with state and federal law. So all of this is required under existing law. These are updates.
Do we have any questions, discussion? Hearing none, do we have a motion to approve policy 4120?
Moved.
I think that was committee
Ms.
member
Yep.
Ellen. Thank you so much. Do we have a second?
Second.
Any further discussion? Hearing none, Dr. Roush, please call the vote.
Chair Brown,
Yes.
acting chair Pierce,
Yes.
Ms. Beasley,
Yes.
Ms. Ellingson,
Yes.
Ms. Klein.
Yes.
That motion carries.
Excellent. And we were able to get through all the policies on our agenda. I will defer to our chair, Judge Brown, if he has any closing comments for us.
I just want to thank you for taking over so ably in my absence and getting through, thank you to the entire committee for getting through the entire agenda today. And we'll keep moving forward. Everybody have a safe and healthy and very good day. Thank you all.
We have a motion to adjourn.
I motion that we adjourn.
Second.
I guess if there's no objection, I guess you are adjourned.
Roll call, please. Yeah.
Roll call.
I will call roll call. Chair Brown,
Yes.
Acting Chair Pierce,
Yes.
Ms. Beasley,
Yes.
Ms. Klein,
Yes.
Ms. Ellingson.
Yes.
That motion carries. You are adjourned.
Wonderful. Thank you all.
Great.
Thank
week,
you.
everybody.